My name is Chief Emenike Ebete. I'm the lawyer to the claimants in the matter just concluded.
Okay.
Delivered.
Okay, just for the benefit of those that will listen to this news, tell us a rundown of the position of the courts in this matter regarding the congresses that was held.
What happened was that my clients purchased funds for state, local government, and world congresses that were conducted, and they were not given nomination funds. So they went to court and prayed the court to restrain the defendants from going on with the congresses. The court actually made an order on the 21st of November 2024 for maintenance of status quo pending determination of the motion on notice. The order was served on APC at East National Secretariat, and that was on 22nd. They proceeded on the 23rd of November 2024 to conduct local government congresses and claimed that they were not aware of the order. Thereafter, on the 25th, they filed processes at the High Court, claiming that they filed an appeal and that the court should stay its proceedings pending the determination of the appeal. We thought that brought the pendency of the suit to the attention of the defendants, that they would have stayed their action. But that was not the case. They proceeded on the 30th to conduct the state elective congresses. So we had to do what we needed to do. We filed motion for mandatory injunction, urging the court to set aside the congresses conducted when they were served with the order of this honorable court.
Okay, we know that the court has set aside those asking your prayers and set aside the congresses. How does this make you feel as a party?
To me, as a lawyer, that justice has been done because they actually stole a match against the claimants. When matter is before a court, the subject matter is there, and the court said, don't do it. And you go ahead in a brazen manner, as the court so found, brazenly, or what the court do. Let's just do it, and we'll go to appeal, and then the court has no jurisdiction. The court has a power under its disciplinary jurisdiction to set aside such acts. The court granted stay of proceedings, but it had to restore its dignity and integrity. What the court has done this evening is in line with the law. And I'm grateful that the law was upheld.
Do you think it will send a message to those who intend to break the law under any guise?
Yes, I think it should. It should, because we don't just go ahead to behave as if there's no court of law. Supreme Court of Appeal, they've said it severally. You can't take the court for granted. Whether the order is worthless or you think is not made at all, what you need to do is to wait, apply for the order to be set aside before you can proceed to do what they wanted to do. In this case, they never did so. They just said, what is that? They made order that they don't have jurisdiction. Let's proceed. What can they do? The court had to frown at it. Not only frown, the court had to bite them and also broke their bones. That's what the court of appeal said they should do in that circumstance.
Okay, my name is Achinike William Wobodo. I held a brief of a senior advocate who is leading me in the matter, and then we represented the defendants in the matter. Well, we will brief our clients. They would appraise, when we discuss with them, they will appraise the issues. We will raise our observations regarding the ruling, and then they will advise us on how to progress. The good thing is that before today, there's already an appeal duly entered at the Court of Appeal with a suit number CA/PH/523/2024, wherein the defendants are challenging the jurisdiction of the court to decide on internal affairs APC. The Supreme Court has said, even in the case of Aguma versus Dele Moses, which arose from APC River State and went all the way to the Supreme Court, where the Supreme Court said the internal affairs of the APC is solely, or a political party is solely the affairs of a political party. It is not for members to decide whether they must be made executive committee members. In any case, the members did not show up, did not comply with the processes, and then there was an application before the court saying that there is an appeal and the matter should be adjourned sine die pending the determination of an application before the court. Well, the court decided in its wisdom to hear an application, proceeded several times before it got to this point of ruling, despite the fact that the attention of court was drawn to the application before the Court of Appeal for stay of its proceedings. The defendants were awarded a cost of 10 million naira. You were in court. And what the defendants were saying is simple. We were not served with the order to maintain status quo. As at 23rd, when we conducted the local government congresses, we were not served, we were not aware. We became aware of this matter after the congresses, and then we proceeded on appeal, So, but the court has made its decision. It's for the defendants to accept it in good faith or challenge it at the Court of Appeal.
Okay, like the claimant said, regarding your comments that the actions of the party are just their internal affairs, like the judge said that you cannot beat a child and expect the child not to cry. And we know that as a country, we are governed by rules, we are governed by the Constitution. So are you backing the decision by your clients to say go ahead with the congresses despite the order?
Which order? If you want us to give you the background to this whole case, was that immediately the APC announced its Congress in October. Some gentlemen went to court, got an ex parte order restraining the APC from conducting the Congresses. In obedience to that court order, APC cancelled its Congresses, shifted it to November. And before the November, the Court of Appeal Port Harcourt Division in appeal number CAPH 371 gave an order, made an order staying the execution of the ex parte order in that case, restrained the claimants in that case from, taking any step from enforcing that judgment. Shortly after that, when APC had done with the congresses, the ward congresses on the 16th, they quickly, another set of individuals quickly ran to court and filed an application. The court, maybe he didn't want to go the way the court went, now granted an order for parties to maintain status quo. That order was not served on the defendant. The bailiff of court, who deposed to an affidavit of service, claimed to have obtained the order on the 22nd day of November, and that he resides in Port Harcourt, and that he traveled to Abuja on the 22nd day of November, served the process at the APC headquarters, returned back to Port Harcourt to depose to an affidavit before 4 p.m. on the same day. And the APC, a security man who is in APC, a security guard in APC, deposed to an affidavit that this gentleman was never seen. In any case, the court order said paste it at the gate. So if the court specifies how you serve the order, assuming they are claiming they served it, it has to be pasted on the gate. If the court say publish on television, it has to be published via television. None of this was done. And there is a counter affidavit as provided by, or as directed in several cases by the Supreme Court for challenging affidavit of service. That was duly done to say this person did not serve APC. But the court has given its decision. The most unfortunate part, I would say, is the part that has to do with the punitive cost. You've set aside the judgment, the congresses, and you are awarding 10 million naira cost against the defendant.
Thank you, sir.
My name is Achinike William Obu. Thank you.